Yes, Lord Paddock.
My Lords, my Lady, can I make one further point on section 217 and show the court one further authority that's relied on against us? The further point is as to why, in our submission, it would be very surprising if section 217 were intended to remove or indeed affect the court's jurisdiction. We say that the purpose of section 217, in a company law sense, is to ensure that there is a power in persons other than the directors in relation to benefits to be enjoyed by the directors where the directors have made the decision. That's the purpose of section 217. And in this case, of course, the decision has not been made by the directors, it's been made by the court as to the desirability in the public interest, in the interest of the charity, for the grant to be made. And that's, we say, a further reason why it would be most surprising if the intention of Parliament had been to affect the jurisdiction of the court to direct the member as to how to perform his statutory responsibility. There's one particular case that Dr. Lehtimaki relies on. He relies on the decision of Mr. Justice Chitty in the Christ's Hospital case, and the court will find that in volume 1 of the authorities behind tab 7, MS 599. And this is a case where the judge was asked to approve a scheme in relation to Christ's Hospital School charity. MS 599, volume 1, tab 7. And the problem was that a statutory provision, section 14 of the Endowed Schools Act, provided that a scheme interfering with endowments could not be made unless the governing body gave its assent. And the court will see that at the bottom of MS 601. It's page 881 of the report. MS 601, the final paragraph, the educational endowments of this magnificent charity were split asunder by the legislation. The severance was effected by section 14. That section enacts that nothing in the act contained shall authorise the making of any scheme interfering with any endowment or part of an endowment, as the case may be, originally given to charitable uses less than 50 years before the commencement of the Act, unless the governing body of such endowment assent to the scheme. So there was a specific statutory provision governing the charity and the endowment as to what could be done and what could not be done. The governors opposed the scheme that was being proposed to the court. They said no. They did not give their approval. And Mr. Justice Chitty, at page, well, it's MS 608, page 888 of the report, picking it up about 2/3 of the way down MS 608, if the court has the passage, he says, I prefer to state my own opinion broadly. I hold that it is beyond the jurisdiction of the court to sanction the Attorney General's scheme in the face of the opposition of the existing governing body. Their title is founded on Royal Charter and is established by Act of Parliament. To whatever lengths the court may have gone, it has never assumed legislative authority. It has never, by a stroke of the pen, at one and the same time revoked a royal charter, repealed an act of Parliament. It has never ousted from its rights of administering the charitable trusts such a body as the present governors against their will. and that too in a case where no breach of trust is charged. There is no authority in the books for any such proposition, yet such is the proposition which underlies the Attorney General's scheme. I consider, says his lordship, I am not at liberty to deprive the existing governing body of their right of control over the income of the funds vested in them, either permanently, as proposed by the scheme, or temporarily, as suggested by the Attorney General in his reply. My lords, my lady, it is not my case that the court can defy the content of a statutory provision. And whereas in that case there is a statutory provision which on its proper construction limits the jurisdiction of the court, then the court must obey that statutory limitation. My submission, as the court has heard, is that section 217 properly construed does not prevent the court from exercising its inherent jurisdiction to direct a member how to perform his section 217 functions. Section 217 is simply not addressing that subject, by contrast with the statutory provision with which Mr. Justice Chitty was concerned, which was an express statutory provision concerned with the administration of a particular charitable instrument. That's the submission. And therefore, I say that Mr. Justice Chitty's statement of principle is nothing to the point. Finally, my lords, my lady, can I mention, without in any way developing the point, that we have also addressed in our written case, it's paragraphs 51 to 55, our concerns about the role of Sir Christopher in making legal submissions in support of Dr. Lehtimaki's position, despite Sir Christopher being a party to the agreement. But Sir Christopher has correctly observed at paragraph 38 of his written case that this is not an issue on this appeal, and I therefore am not going to add to what we've said in writing, save that the episode demonstrates with clarity in our submission the wisdom of the Chancellor's recognition in his additional pragmatic considerations, as he described them, paragraph 153 of his judgment, MS 296, of the need to direct Dr. Lehtimaki to approve the grant to avoid the risk of further litigation. And it is striking indeed that the original agreement which the court has seen at Appendix tab 16, if I could just ask the court to turn up, Appendix tab 16 of the core volume, and it's at MS 394, this is the letter of intent. It is of some interest to note in the second paragraph that my client, Ms. Cooper, and Sir Christopher end the second paragraph by noting that all outstanding matters and all conflicts have now been settled. Sadly, 5 years on, we await the judgment of the court before that can be the case. In conclusion, my lords, my lady, we respectfully invite the court not to state in narrow terms the court's powers in relation to a charity. We respectfully submit that the powers of the court in relation to charity should accord with the purpose of charity law to protect the public interest. How those powers are to be exercised will inevitably depend on the particular circumstances of the particular case. As the Chancellor explained, this is an exceptional case, and the steps that the Chancellor took in my submission were well within the jurisdiction and the discretion that the Chancellor enjoys on the findings that he made. That's what I wanted to say to the Court, unless there are other matters that I could seek to assist the Court on.
Thank you very much, Lord Pennick.
Thank you very much.
Mr. Tobe, do you follow? Mr. Morpus.
Lords, my lady, there are two arguments that have been put forward by the appellant and the Attorney General in their written cases as to why the Chancellor's order was an order that was entitled to make. And I say the written cases, there are two arguments. One seems to be advanced with rather more enthusiasm than the other. The first is that there is a general inherent charitable jurisdiction. That's a case advanced by the friend Pierce for the Attorney General. And the Attorney General says that that is an argument we could adopt in favour of the Chancellor's approach. The case is almost entirely founded on re Lang, and I'll come to the detail of that in due course. We say it simply doesn't work for authorities. The second argument is that the Court has the same power generally in relation to trusts, charitable and non-charitable. My learned friend, Mr. Pierce, the Attorney General, gives you some of the arguments around that, and I will deal with them later. He has no enthusiasm for that and doesn't invite you to adopt it. He said it would be a substantial. Doesn't make the final jump from saying Lehtimaki and Brewers allows you to intervene, and therefore the Court has some power to actually tell trustees how to act. Startling argument, if correct. It would mean that the Court would walk in over trustees' discretions at the request of beneficiaries or other persons. There is a third argument that we thought had died a death in the Court of Appeal, or at least after we'd left the Chancellor. That is the argument that the surrender of discretion by the trustees of SIF has somehow bound my client, Dr. Lehtimaki, and their members, such that the Chancellor was entitled to, thank you, such that the Chancellor was entitled to make the order that he did. As I say, I thought that argument had died a death, and I'll take you in a moment to where the Court of Appeal dealt with it, but it has revived itself, and I do have to deal with it. I'm going to focus very much, though, on the first argument, because we really say this appeal stands or falls on that. Does the Court have some special jurisdiction in relation to charities that allowed the Chancellor to make the order that he did? And the Court has a mass of authority before it. You have over 100 cases and articles before you. This case has been considered by some of the most experienced chancery practitioners around today. It's been considered by several very learned equity judges already. And no one has been able to come up with a case in which a court in a charity case has made an order such as that which the Chancellor made. That doesn't mean the Chancellor didn't find a jurisdiction which no one else had recognised before. It is possible, but we submit it is unlikely. And Mr. Pierce, for the Attorney General, very fairly concedes that he has found no such case.
When you say that, you mean giving the instruction to the member to vote in favour of this?
Yes, my lady, I do.
That's a very specific matter, but there are certainly dicta in the cases we've been shown, aren't there? Or not just dicta, there are judgments which support a very wide jurisdiction.
I would say no, my lady, and I'll take you through them in a moment. I'm going to take you to a case which my learned friend footnotes but didn't take you to, but I say is a very good starting point in a moment, which deals with the parents patriae jurisdiction, where the House of Lords says in clear terms the parents patriae jurisdiction is not just some free-ranging jurisdiction where you walk in and rewrite trusts. It is a narrow jurisdiction which has developed over time, and in our submission, when one looks at all the cases, and I will take you through them in detail, there is nothing that comes close to the sort of order which the Chancellor made in this case, either in the trust jurisdiction or in the charity jurisdiction. I do say before I deal with the detail that it is worth noting how the Attorney-General's position has changed in this litigation. In the Court of Appeal, the then counsel for the Attorney-General simply adopted in his written submissions and developed my learned friend Lord Panic's submissions on jurisdiction. He adopted them entirely. My learned friend Mr. Pearce has taken a much more measured approach, and we say a much more correct approach on the law. He and I agree on almost every point on the law. If one goes through his skeleton, I find myself going tick, tick, tick as we go through, until we get to the very final point, which is, can the court or should the court extend the law to enable an order such as that the Chancellor made to be made by courts? That's the only point really on which we disagree. But up until that, we're in agreement on everything. Dealing with the 3 points, just to give you a flavour of what it is we say about each, and I will come back and develop each of these. On the charitable jurisdiction point, we make 4 submissions. First of all, we say there is no support in the authorities for a charitable jurisdiction going beyond the trust and the scheme jurisdictions. And the fact that the court is exercising an inherent jurisdiction on the basis of parens patriae does not mean that that jurisdiction is unlimited. Second, we say that the scheme jurisdiction doesn't help the appellant here. Again, my learned friend's case has changed somewhat on this. There's nothing, Lord Wilson rightly observed, there is nothing in my learned friend's written case suggesting that the Chancellor had somehow directed a scheme. That was an argument that was advanced in the Court of Appeal. It didn't rear its head again in my learned friend's written case, but it's one we can deal with on the authorities. We have all the cases here, and it's wrong. But the Chancellor wasn't asked to direct a scheme. The Charity Commission didn't authorise an application to the court for a scheme. But more importantly, there is no basis for a scheme. What my learned friend has glossed over in all his submissions is 2 issues on the scheme. First of all, the threshold for getting into a scheme, what you have to show to get an administrative scheme off the ground, that the court actually has some power. And what you have to show is that the machinery of the charity is not working. That's what Lord Justice Russell says in clear terms in Chinachem, and I'll take you to it in a moment. That's one of the passages that was omitted. You have to show the machinery of the charity has failed. That's the threshold test, and it doesn't apply here. There's nothing wrong with the machinery of SIF. But my third point is that even if you can get over that threshold, you've still got to ask, what power does the court then have to do something by way of a scheme? What does a scheme actually mean? And the answer is the one that the Court of Appeal gave. It's to be found initially in Chinachem, Lord Walker in Chinachem, that a scheme is a means by which the court rewrites the constitution of the charity. And there is a world of difference between rewriting the charity's constitution and walking in and taking over the trustee's discretion and telling them what to do. And my learned friend's repeated point in his written case that surely the court must be able to do something less intrusive because it can do a scheme, misses the point that these are quite different exercises. A scheme is something the court is perfectly entitled to do. It can rewrite the constitution, but recognising the principle of non-intervention, what the court does not do is actually tell the trustees how to exercise that discretion. In the case of courts, that is laid down in the authorities I'll show you. In the case of the Charity Commission, that is specifically in section 20 of the Charities Act, that the Charity Commission may not administer a charity. It may not take over the functions of the charity trustees. And it would be very odd if the Charity Commission, which is largely meant to take over the function of the court in the way in which charities are dealt with and administered, if it didn't have that jurisdiction, but somehow the court had acquired it or retained it. The fourth point we make in relation to the charitable jurisdiction is the section 2171, that where Parliament has given a power of veto or approval to members, that is something that the court ought to respect. That's what I'm going to develop on the charity side. On the trust side, as I say, it doesn't necessarily come to any conclusion, the trust argument. I do need to deal with it, particularly because my learned friend, Mr. Pearce, is coming after me, and I don't want to leave points unanswered that he may want to deal with. There are 3 points we make on the trust point. The first is that the Letterstead and Brewers jurisdiction is an exceptional one. It requires a strong finding to be made against the trustee. It requires the court to find that the trust property will not be safe or the trust will not be properly executed, and I will show you authority to that effect in due course. In the present case, of course, there is no such finding, and importantly, Lehtimaki and Brewers was never even mentioned to the Chancellor. This is not the basis on which the Chancellor exercised his discretion. There is no finding of fact to support a Lehtimaki and Brewers type intervention. Secondly, and in any event, neither my learned friend Lord Panic nor Counsel for the Attorney General then make the leap from Lehtimaki and Brewers, how one gets from removing trustees to some power to take the further step and actually tell trustees how to act. There's simply no explanation for how one makes that leap, but that's an important part of the argument if one's going to say that the court has the power in relation to all trusts to tell trustees how to act. And then the third point in relation to the trust jurisdiction is the fiduciary duty one. This only applies if members are fiduciaries. If they aren't fiduciaries, none of this matters. There is only charitable jurisdiction, nothing else. I'll come to that right at the end. Now, my lords, my lady, there is, as I say, a third point that has been developed orally by my learned friend Lord Panic, which is what I'll call the surrender of discretion. That is, members are part of the administration of the charity, and once the trustees had surrendered their discretion to the court, that effectively meant that anyone who was part of SIF was bound. The Chancellor made his decision, and that binds members of SIF, so why are we here? The Chancellor's made his decision. My lords, my lady, that has a number of flaws in the argument. First of all, the starting point is wrong, because it assumes that what is happening in this case is that the trustees of the charity have made a decision to make a grant in the normal way. They're entitled to do that under the memorandum and the articles. We saw that earlier. They make a grant, the money is paid over to the person or charity to whom they're giving it, and that's the end of the story normally. The members have nothing to do with it. They have no role in any of that. It's a trustee decision. The difficulty is that if this is not a normal grant, which this isn't, if what is happening is the trustees are making a payment to one of their own, then Parliament has stepped in and said, well, in those circumstances, members have to be involved. And Parliament hasn't said there needs to be an independent review of this by, for example, the Charity Commission or by the court. Parliament has said there need to be two things. There needs to be the Charity Commission giving its approval under Section 201 of the Charities Act, and members need to give their approval under Section 217 of the Companies Act. And it isn't just some oversight that somehow some quirk of company law legislation has found its way into the charities jurisdiction here, because Section 201 comes after Section 217. And so when Parliament enacted Section 201 and said the Charity Commission has to give prior written approval before the members give their approval under Section 217, it clearly envisaged that there would be both these processes, the Charity Commission giving prior written approval, followed, if the Charity Commission says yes, by the members then deciding whether to say yes or no. And in our submission, that is a very important distinction, that it's not enough simply to take a step back and try and take a global view and fudge it, as I would say my learned friend does, and say, well, the Chancellor has said this is all in the interests of charity, therefore this is all fine, the members have no further role to carry out.
But the other distinguishing feature is that the 217 approval is required as an element of a much greater scheme of in which the Charities Commissioner are involved, i.e. in the transfer to the Big Win Philanthropy charity. It's an incidental part of a much larger scheme in which the Charities Commission have an interest.
Well, your Ladyship says scheme, of course.
Scheme, all right, plan, project.
I'm sorry, I didn't want to get hung up on it being a scheme in a technical sense. It is part of a much bigger picture, my lady, indeed, but these are all constituent parts, all doing different things. And my submission is that if Parliament had simply wanted some independent scrutiny, it could have just said, well, Charity Commission sign off on this. If the Charity Commission signs off on it, why do we need anyone more to look at it? Why do we need members to
But
agree?
it does involve slicing it up into small portions.
But that is what Parliament has done. It has sliced it up. It's given the trustees, well, the trustees had their discretion generally. They kick it off by deciding whether or not to make this grant. Because of the fact that we're in a self-dealing situation here, we then get the two other bits that Parliament has superimposed, the slices of the Charity Commission and then the slice of the members.
But 201 doesn't oust the jurisdiction of the commissioners in relation to approvals of transactions generally. There are indeed other sections dealing with approvals of transactions. It's simply a negative thing. If there is a resolution for payment of compensation of loss of office,
Yes.
specifically you have to look under 201 to get the consent of the Charities Commission. But there could be other involvement of the Charities
Oh, there could be, my lady.
other involvement of the court.
There could be, but it's all got to be based on proper jurisdiction rather than just taking the view that trustees have surrendered their discretion, that's good enough, a court has looked at this, that must be the end of the matter. What one's got to look at in our submission is what was it that the trustees surrendered to the court? It was their discretion. They had no power to surrender the discretion of members to the court.
If it's dependent on surrender, but that's part of the argument, isn't it?
Well, yes, I'm trying to slice it up. As what seems to have re-emerged, and what I thought had died a death, was the argument that found favour with the Chancellor, and seems to have been the basis on which his primary motive was trustees have surrendered their discretion, that effectively binds SIF, that binds the members, that's the end of the matter, because I think it was my Lord Kitchen pointed out earlier in paragraph 155 of the Chancellor's judgment, he says things might have been different had the trustees not surrendered their discretion. And he says earlier on in the judgment, the question is, what is the effect of the trustees surrendering their discretion? So that seems to have driven his thinking.
But surrendering their discretion is sort of labelled in this case, and doesn't convey the whole of that which has been surrendered. As I understand it, what has been surrendered to the court, in the sense that the court has been asked to decide it, rather than just bless somebody else deciding it, is whether this transaction is in the interests of the charity.
But for the trustees, it's the trustees, my lord, who have come
I
along.
accept
and
that they're the people who brought it to the court, but
Yes.
the question which they've asked the court to determine for the sake of the company, because they're acting on behalf of the company, as I understand it, is this transaction, this proposed transaction, in the interests of the charity?
It's the words "for the sake of the company," my lord, where I would say that one needs to focus very carefully on what it is that's been surrendered and who the Chancellor was acting for. Because that is the crux of this point. That perhaps I can show you the detail of it, my lords.
Yeah.
I don't want to get too bogged down.
I'm simply putting it down as a sort of marker, because
Yes,
to my mind, just saying X has surrendered their discretion doesn't really tell you what it is and what issue the court has been asked to determine.
No.
And as between who and with what consequence.
Absolutely, my lord. And I'm keen that we are very precise on this, because it is very important, because this was the argument that seemed to sway the Chancellor, and I'm keen that it doesn't rear its head and get dealt with in the same way by your lordships, because it's, regardless of all the charitable jurisdiction, regardless of all the trust jurisdiction, this was the Chancellor's short way through it. And it's wrong in my submission when one understands what exactly has been surrendered. And that's why I've slightly diverted into this at this stage, but it's probably useful to deal with it before I go on and deal with the charitable jurisdiction and the trust jurisdiction. Because if the Chancellor was right about this, and it's not a point that was raised by my learned friend in his written case at all, if my Chancellor was right about it, it's a short way through everything. But perhaps I can start, Lord, with looking at what the Chancellor was actually, what he understood he was doing, and this is in the core bundle, tab 4. If we pick it up at page MS 256.
Sorry, MS.
256.
Thank you.
Paragraph 11.1 of the Chancellor's judgment, he didn't like the list of issues which had been produced by the parties, so he produced his own, and this was his list of issues that he brought into court on day one, I understand. And he says in 11.1, he says, against that background, the main issues for the court's determination are as follows. Is this a case in which the trustees seek the court's approval to a momentous decision they have in their discretion decided to take? So that's category 2 in Public Trustee and Cooper. Or a case in which they have surrendered their discretion to the court. That's category 3. So it's a surrender of their discretion, the trustees' discretion. And then if we pick it up again in paragraph 69, this is at 275, MS 275. Paragraph 69, he says, on issue 1, therefore, so answering the point in para 11.1, I decide that this is a case in which the trustees of SIF have, in the circumstances that have occurred, surrendered to the court their discretion in relation to the making of the grant. That's, in fact, the passage my Lord Wilson pointed out earlier to a learned friend. And then in paragraph 154, which my learned friend did take you to earlier, the legal basis for the Chancellor's decision, page 297, MS 297, says the legal basis for my decision is, in my judgment, to be found in the particular circumstance of this case. Here, both the Commission and the trustees of SIF have decided that their discretion to approve the grant should be exercised by the court. So it's the trustees. That discretion has now been exercised by the court. The discretion so exercised binds the charity and the charitable company SIF. Its management is only divided between trustees and members for specific purposes. Here, the trustees of SIF bound SIF in relinquishing their discretion to the court, and the court order will bind SIF in deciding that the grant should be made. Now, that, my lords, my lady, is where we say the Chancellor fell into error. And that was not an argument that was advanced in the Court of Appeal in support of the Chancellor's order. It was solely on the basis of charitable jurisdiction and trust jurisdiction. And I'll take your lordships in a moment, my lady, to the passage in the Court of Appeal where they note that. That is wrong because it's essentially a bootstraps argument. It's the trustees come along and surrender their discretion to the court. The court is exercising the trustees' discretion and then says, well, I can also exercise the members' discretion.
In that sentence, in fairness, he's simply talking about deciding whether the grant should be made. He's not talking about the 217 approval.
Well, he goes on to say that the effect of that is that the members can't gainsay it. That's the bit my learned friend read you.
Yes.
Yes.
Because the member doesn't have a free vote.
Yes. Yes, my lady. If I could invite you to turn back to the court, how the Court of Appeal dealt with this. It's back at tab 2, paragraph 27, MS 232. Perhaps if one goes back to paragraph 26, just to get the context, since we've just looked at paragraph 154 of the Chancellor's judgment, the Court of Appeal records there, Mr. Morper suggested that 4 ingredients can be extracted from paragraph 154 of the judgment. One is that the trustees of SIF bound SIF in relinquishing their discretion to the court. Second is the Charity Commission contemplated that the court might make directions, etc. The third and fourth are encapsulated in the sentence, the member does not have a free vote in this case because he is bound by the fiduciary duties I've described and is subject to the court's inherent jurisdiction over the administration of charities. In other words, the Chancellor was relying on A, the fact, as he saw it, that members of SIF have fiduciary obligations, and B, the court's inherent jurisdiction over charities. The battleground before us was on these last points. We did not understand either Lord Pannick or Mr. Mullen, who was then appearing for the Attorney General, to contend that the court could direct Dr. Lehtimaki how to vote merely because the Charity Commission envisaged that directions might be given in relation to Section 217 resolution, or because there had been a surrender of discretion. They were, moreover, right not to advance such submissions. The fact that the Charity Commission contemplated the possibility of directions in connection with a Section 217 resolution cannot have served to confer on the court the power to override Dr. Lehtimaki that it did not otherwise have. Further, SIF's trustees had surrendered their discretion to the court, but had, as we see it, no power to surrender any discretion that Dr. Lehtimaki enjoyed, and Dr. Lehtimaki himself has been very clear that he is not surrendering any discretion. And that, my lords, my ladies, where it was left in the Court of Appeal. That argument was not pursued at all, orally, or I think even in writing before the Court of Appeal. That is why I said I'd understood that the argument was effectively dead. Nevertheless, we do have fortuitously, one of the authorities that I did cite to the Court of Appeal on this in the bundles, it's in Bundle 5, and it's probably the most important one. Bundle 5, tab 92, starts at MS 2419. It's the case of Shaw and Shaw. And I cited this along with some other authorities to the Court of Appeal in my skeleton, but as it happened, none of this was needed, given the point wasn't argued in the Court of Appeal. The relevant passage is at page 2440. Halfway down the page, in the first full paragraph, about 6 lines in, there's a sentence starting, "A company is an entity." A company is an entity distinct alike from its shareholders and its directors. Some of its powers may, according to its articles, be exercised by directors. Certain other powers may be reserved for the shareholders in general meeting. If powers of management are vested in the directors, they and they alone can exercise these powers. The only way in which the general body of the shareholders can control the exercise of the powers vested by the articles in the directors is by altering their articles, or, if opportunity arises under the articles, by refusing to re-elect the directors of whose actions they disapprove. They cannot themselves usurp the powers which by the articles are vested in the directors, any more than the directors can usurp the powers vested by the articles in the general body of shareholders. The law on this subject is, I think, accurately stated in Buckley on Companies. So, my lords, my lady, I cited that and a number of other authorities to the Court of Appeal. That's the only one we've got here, but that is the most authoritative. It's the Court of Appeal saying what is really uncontroversial, that someone can't surrender a discretion which they don't have. And the Chancellor's conclusion on this depended on them being able to do so. So, my lords, my lady, I've taken a bit of a diversion with that, which I hadn't intended, to deal with this argument and the way in which it's come about. I may need to come back to it later. There may be some more references I want to pick up on that I haven't had the chance to pick up on over lunch. But I was going to then move on from that in a moment to deal with the more substantive points of charitable jurisdiction and trust jurisdiction, because we say that is no shortcut. It isn't an answer. There might have been an answer there if the Chancellor had made a finding that no reasonable fiduciary could possibly have disagreed with him.
But if he's made a finding that this transaction is in the interests of this charity, and I think that paragraph you showed us is it 154?
Yes.
Does include a finding to that effect, although you didn't need to read it out for your purposes. I think it's there.
Yes.
And if the only question which would properly activate the minds of the member in deciding whether to approve it or not under Section 217 is this transaction in the interests of the charity, why has it not been a consequence of the trustees referring that, what you might call, best interest question to the court and the court deciding it, that it is done and dusted as between the company, the directors or the share trustees and anybody else who's party to the proceedings, including this case, Dr. Lehtimaki?
Well, my lord, it's only done and dusted to the extent that the Chancellor was exercising the jurisdiction of the trustees, and that's why I say one's got to look at this in a segmented way. Because the Chancellor... Can I take you to another passage in the Chancellor's judgment to explain where I'm going, my lord? If I could invite you to go to MS 292. Right, I can see that your lordship is troubled by that, and I will come back to it. But if I can just show you one other passage in which lays the foundation for this submission. MS 292, it's paragraph 135 of the judgment. And the Chancellor says here, it doesn't seem to me necessary or appropriate to say where I am on Mr. Crow's scale. And this was the question of, had the Chancellor just got over 50% in thinking this was in the interest of the charity, or was he somewhere up by 95%, thinking it's blindingly obvious it's in the interests? He says, I've made the clear decision the grant should be approved for the reasons I've sought already to give. It's of no help to say how strongly I feel about that decision. I'm not saying that no reasonable trustee or fiduciary could disagree with my view, nor could I, bearing in mind the way the matter was argued. nor for the avoidance of doubt am I saying that anyone who disagreed with my view would automatically be acting in bad faith. Again, that is not what this litigation was about. So I say, if the Chancellor had felt able to say, look, no reasonable fiduciary could possibly disagree with me, therefore, although Dr. Lehtimaki is carrying out a separate exercise when he's asking whether or not this is in the interests of charity, then I would be in difficulty. Dr. Lehtimaki would be in difficulty. But where the Chancellor has said, I found this a difficult exercise, I've decided somewhat possibly counterintuitively that this is a grant that should be approved. That, and a
But because it's in the best interests of the charity.
in the Chancellor's opinion, my
Yes,
Lord,
but that's the basis of his decision.
Yes, but exercising the discretion of the trustees. I mean, that's the difficulty, my Lord. And unless one can say that the trustees' surrender of their discretion binds Dr. Lehtimaki in the exercise of his Section 217 power, then the fact that the Chancellor has reached this decision is something for Dr. Lehtimaki to take into account, but it can't bind him. It's the bootstraps argument, my Lord. The Chancellor has... I can see that your Lordship is troubled by this, and it was...
My trouble is not... I quite understand that it doesn't necessarily follow from the fact that one group involved in the company's management, here the trustees, surrenders their discretion
Yes.
to the court, that therefore that necessarily involves the surrender of discretion by some other group involved in the company's management,
Yes.
here the members.
Yes.
But where the question which the court has to answer in order to decide what should be done is this transaction in the interests of the company? And you may say I'm wrong about this, but let's assume that is the same question which the member would have to decide in deciding whether to approve the transaction under Section 217, namely, is this transaction in the interest of the company? Brackets, even though a director or an associated company is getting a payment. Then why isn't that a unitary question? Once the court's dealt with it, it's been dealt with.
Well, because it's a question that the question is the same, my Lord, but the people who are being asked to answer that question are different. And what is important from what Parliament has laid down under Section 217 is that members give their view on it. That's the difference, my Lord.
I can quite see that Parliament has thought that the director's word should not be the last word.
Yes.
And that's why the member gets another look at the question.
Yes.
But if the court has, at the director's invitation, taken over the determination of the question, it's been determined by the court in proceedings to which the company is a party, the directors are a party, and the members are a party, what's left to be rethought or redecided?
Well,
I suppose I'm just re-echoing what the Chancellor says, but it does strike me as quite an odd question.
Well, with respect, your Lordship is echoing what the Chancellor decided and what my learned friend didn't feel able to argue in the Court of Appeal. But that doesn't necessarily mean it was wrong, of course, my Lord, I say with respect. But I do say it is wrong, and the reason I say it is wrong is because one's got to identify what it is Parliament has asked, and Parliament has asked the members, with their particular knowledge, with their particular experience, to answer this question.
It's not the same question. The Section 217 question is about payment in connection with loss of office.
Yes.
That's what they're focusing on
Yes.
under 217. The proposition before the Charities Commission or before the court under its inherent jurisdiction is the totality of the transaction from the point of view of making a large payment out of one charity's assets to another
Yes.
charity, setting up another charity, and so on. It's a quite different question from the very limited question which the member has.
Well, it is, my lady, but I'm sorry, I was trying to deal with Lord Briggs' point, which I thought was that the questions were the same.
It's part of
and
your answer, that's
they're-
why I've raised it.
Yes, no, I'm grateful. My lady, the question which the court was asking was, is this in the interests of the is it in the interests of the charity? Although the Chancellor also asked the question, is it in the interests of charity generally? Because one of the things he took account of was the fact that an additional 40 million was going to find its way into the pot from Miss Cooper if this is approved. The question the members are asking is, should we approve this? And they aren't given particular guidance on how they have to go about answering that question. So in one sense, the question could be different, but they are, this sort of trespasses into the fiduciary duty side, they are asking it with the best interests of SIF at heart. So the question that Dr. Lehtimaki is going to ask himself, if he gets the chance to ask, is this something that is in the interests of SIF? And I said earlier they are the same question. In fact, they may not be quite the same question because the Chancellor is looking at things more widely from the point of view of charity generally. Dr. Lehtimaki is asking the question, is this something I should approve for SIF? And his only duties, to the extent there is any duties, are to SIF. And so they may actually be different questions, my Lord, although they are broadly the same. But that rather highlights the point that I started with, that this is a member's decision. It's a decision that Parliament has given to the members to exercise with their particular expertise, with their particular knowledge, with their particular skill. And it's therefore not the same as what the court is doing. The court has different expertise, different skill, different information. Obviously, one of the concerns that Dr. Lehtimaki has, having been brought into this litigation on day 3 of day 4 of a trial, is that his opportunity to inform the Chancellor of the sort of considerations that he would take account of was fairly limited. As I say, we've made no complaint about that in the sense we never objected to we said, well, look, we're trying to be constructive here, we're not asking for an adjournment, we'll deal with things as best we can. But we weren't in a great position to be putting in information and evidence in front of the Chancellor. And one of the things that Dr. Lehtimaki has said that he wants to do, if he gets the opportunity to make this decision, is to engage some consultants to look at what's going to happen to this money. This hasn't been done. No one's looked at what is going to happen to the money if it's paid over to BWP. Is it going to be spent better, worse, as well? And that, to Dr. Lehtimaki, is a very important consideration. Although my learned friend has not really touched on this, if your lordships have any concerns about Dr. Lehtimaki's approach, I do invite you, my lords, my lady, to have a read of Dr. Lehtimaki's second witness statement, if you haven't done so, which sets out very carefully, it's unusual, it's written by him, it sets out very carefully the approach which he will take in considering the grant. And it's a very careful, very measured approach, and it explains the information that he feels was not before the Chancellor, but that he as a member would like to obtain to be able to exercise his statutory function. Now, my Lord, I'm not sure I can give you a better answer immediately. Perhaps I can come back to that. I was trying just to give you an introduction to it. Yeah. It's rather developed into something much longer. But perhaps I can come back to that.
I just wanted you to have a clear understanding that if the point has force, it's not so much just because somebody has surrendered discretion, it's what it's about and what the issue is which the exercise of that discretion requires to be decided.
No, I appreciate your lordship's point, and perhaps I can come back to that. I was going to deal with them each in order, and I've got slightly dragged into the third point before the other two. If I can go back to where I started, which are the other two points which my learned friend relies on in his written case, and the arguments the Attorney General relies upon. It is worth bearing in mind, of course, no doubt your lordships will, and my lady will hear what the Attorney General has to say about this point, but it's not something that appears in the Attorney General's case at all. He is focused on the charitable jurisdiction and the trust jurisdiction. It is something that has rather reared its head out of my learned friend's oral submissions. I was going to start with the charitable jurisdiction, and I said a while ago that I would take you to a House of Lords decision, which is very informative on how one deals with the parents patriae jurisdiction. And perhaps we could pick this up first in my learned friend Lord Panick's skeleton argument, starting in tab I of the core bundle, starting at MS 165. And
skeleton argument 165.
Yes, my lord. Page 93. I'm sorry.
Oh,
I'm sorry.
very well.
Something's gone wrong with the references there. Tab I, MS 93, my lord.
Yes.
Sorry. Paragraph 21. My learned friend here refers to the Royal Society case. Now, he didn't take you to this in his oral submissions, but it's essentially a similar case to Reed Lang in terms of the exercise of the scheme jurisdiction. And he relies on it here for what's said by Dennis Buckley, as he then was as counsel for the Attorney General, saying the court exercising over trusts an equitable jurisdiction. Charities occupy a special position, for the court has a wider jurisdiction in respect of charitable trusts than in the case of private trusts, owing to the Crown's function in acting as parens patriae in matters relating to the charity. And you will recall this morning there was a lot of reference to parens patriae as being the foundation for the charitable jurisdiction. It's said to be the foundation for the inherent jurisdiction. And then in footnote 4, my learned friend contrasts the court's inherent jurisdiction for what he calls ordinary trusts, which he says is very limited, and he refers to the case of Chapman and Chapman. And perhaps I could invite you to turn that up to see what Chapman and Chapman actually tells us, because it is, in our submission, very informative on the issues which is facing the court here related to charities. It's at Bundle 1, tab 11, starting at MS 661. Chapman and Chapman is actually as close as we get to the issue in this case, without it being a charity case. It's a case where the issue was the extent of the court's inherent jurisdiction over trusts in relation to infants and the unborn. And what had happened was that in the Court of Appeal, Lord Justice Denning, as he then was, in the minority, had argued that the court's parens patriae jurisdiction gave the court a wide inherent jurisdiction by which it could rewrite trusts where it was in the interests of the beneficiaries. And here the reason he wanted to rewrite the trust was because the estate was worth about £65,000. There was going to be a very large estate duty payment to be made of around £30,000. So Lord Justice Denning said it's obviously in everyone's interest that these trusts can be rewritten to avoid this iniquitous payment being made. He was in the minority there. The majority of the Court of Appeal, Lord Evershed and one other, didn't agree with him. And it came up to the House of Lords. And interestingly, Mr. Buckley was again brought in as amicus curiae for the Attorney General. And I'll show you in a moment a little of what he says. But I was going to start with the judgment of the Lord Chancellor, which is at MS 675. Lord Simons, Lord Chancellor, at the top of 675, he says, "Your Lordships are invited to hold that a judge of the Chancery Division of the High Court of Justice has an inherent jurisdiction in the execution of the trusts of a settlement to sanction on behalf of infant beneficiaries and unborn persons a rearrangement of the trusts of that settlement for no other purpose than to secure an adventitious benefit, which may be, and in the present case is, that estate duty payable in a certain event, as things now stand, will, in consequence of the rearrangement, not be payable in respect of the trust funds." This argument, which found favour with Lord Justice Denning, is based, as I understand it, on two separate lines of thought, which are for this purpose blended. On the one hand, it said that the Chancellor, the Court of Chancery, the Chancery Division and the High Court of Justice, exercising in turn, on behalf of the Sovereign as parens patriae a peculiar jurisdiction over infants, had and has power to dispose of an infant's property in any manner beneficial to him, in which he, if of full age, could have disposed of it. And on the other hand, it said that the same court whose duty it has been for some centuries to execute and administer trusts has jurisdiction to remodel those trusts by agreeing on behalf of infants and unborn persons to any rearrangement which it deems to be advantageous to them. So it's very close to the present case. The argument is very similar. The parens patriae jurisdiction, which exists really only in three areas. One is charity, two is infants, and the third was in relation to the mentally ill, but has now effectively been abolished by statute, or is dormant as a result of statute. That's why I say this is as close as we get to the present case without it actually being the present case. And then informatively, over the page at 676, the Lord Chancellor expresses his views on this. He says, "I'm unable to accept as accurate," this is at the top of the page, first full paragraph, "this view of the origin, development and scope of the jurisdiction of the Court of Chancery. I don't propose to embark on the arduous task of tracing to its sources this peculiar jurisdiction. Many volumes have been devoted to it, and I've refreshed my memory by reference to some of them. Nowhere can I find any statement which would support the broad proposition for which the appellants contend. Moreover, the law reports contain many cases in which the scope of the jurisdiction has been discussed, every one of them a work of supererogation if its scope was unlimited. And pausing there, that rather echoes what I'd said in my written case, that if my learned friend is right about the broad power that he says exists to interfere where expedient, it's pretty odd that judges have spent 400 years going over this. And then the next paragraph, my lords, in my opinion, the true view that emerges from consideration of jurisdiction through the centuries is not that at some unknown date it appeared full-fledged and that from time to time timid judges have pulled out some of its feathers, but rather that it's been a creature of gradual growth, though with many setbacks, and that the range of its authority can only be determined by seeing what jurisdiction the great equity judges of the past assumed and how they justified that assumption. It is, in effect, in this way that the majority of the Court of Appeal in the present case have approached the problem, and in my opinion, it is the right way. He then goes on to say that may not be logical, but skipping on a few lines, he says, we're as little justified in saying a court has a certain jurisdiction merely because we think it ought to have it, as we should be in declaring that the substantive law is something different from what it has always been declared to be, merely because we think it ought to be so. It's even possible, he says, that we are not wiser than our ancestors. It's for the legislature, which does not rest under that disability, to determine whether there should be change in the law and what that change should be. Now, Lords, I hesitate over the second to last line, but I do say that one should have regard to what the great equity judges of the past have done and why they've done it. And that's where I'm going to take you in a moment, to the extent my learned friend hasn't. But this is not a case of there being some free-ranging, wide-ranging jurisdiction from which one just takes what bits one needs. One looks at the jurisdiction the courts have exercised and asks, what was it and why? And then two other passages I wanted to show your lordships. On 677, the Lord Chancellor says, the major proposition I state in the words of one of the great masters of equity, I decline, said Mr. Justice Farwell in Re Walker, to accept any suggestion that the court has an inherent jurisdiction to alter a man's will because it thinks it beneficial. It seems to me that's quite impossible. It should then be asked, what are the exceptions to this rule? And he runs through the various limited exceptions. And then going down to the middle of the page, he says, nothing is more significant than the repeated assertions by the court that mere expediency was not enough to found the jurisdiction. Lastly, and I can find no other than these four categories. So he says there are limited exceptions, but there is a jurisdiction, and simply saying that something is expedient in the interests of infant beneficiaries is not enough to give rise to a jurisdiction. Then one sees a similar comment in the judgment of Lord Asquith, which starts at MS 701. At the bottom of 701, Lord Asquith says, I would venture to record my view that the inherent jurisdiction of the Court of Chancery in this sphere is limited to three classes of cases, maintenance, salvage, and compromise, and the Court's exercise of jurisdiction in these spheres is limited to those spheres and is not simply the exercise in particular circumstances of the far wider jurisdiction claimed by the Court, for the Court by counsel for the appellants, a jurisdiction limited only by two conditions, consent of interested adults and benefit to interested non-adults. If that wider principle had been valid, a formidable volume of judicial learning and forensic argument directed to the question whether the facts of the case bring it within the three privileged compartments must have been wasted. Why this expenditure of time and erudition if the alleged broad principle was always there, offering a shortcut? My lords, I've spent a little time on that because I do say it is a useful indicator of the way of approaching the parents patriae jurisdiction, and that the way my learned friend approaches it is simply wrong to see it as this wide-ranging jurisdiction which permits the Chancellor or the Chancery Division or the Court to do whatever it wishes. It's a narrow jurisdiction, and it's one that has developed over time with set rules, and those rules should not be infringed on unless there is a good reason. I won't take your lordships to it, but I just ask your lordships to note that Mr. Buckley was amicus for the Attorney General, and he was firmly against the idea that there was some wide-ranging jurisdiction here. It's at 671 and following, and he argued against there being a general jurisdiction, which all the other counsel were arguing for, and he was found to be right. With that introduction, I want to then look at some of the authorities on the charitable jurisdiction and the scheme jurisdiction. And the one thing that echoes throughout these cases and throughout my submissions is the question that Mr. Buckley, the Lord Chancellor, and Lord Asquith put in Chapman, which is why, if there is simply a power to do what is expedient in relation to charities, why do we have all this learning over hundreds of years as to when the court will intervene? It is, in my submission, a fair question and a very difficult one, if not impossible, for my little friends to answer. But also, turning to what law there is on the charitable jurisdiction, could I invite you, first of all, to look at the more general statements that appear in Halsbury's and an old edition of Tudor. They are found in Bundle 3, and the first one is at tab 45 of Bundle 3, MS 1605. And the relevant passage starts at MS 1607. This is the volume on charities in Halsbury's Laws, paragraph 536. As a general rule, the High Court has jurisdiction to enforce the observance or redress breaches of all trusts, charitable as well as private. The court cannot exercise its charitable jurisdiction if no trust is ascertained. The jurisdiction in the case of charities is more extensive than in the case of private trusts. Where the trust is charitable, the court has jurisdiction not only to enforce it and to redress all breaches, but also in certain circumstances to make schemes for the administration of the charity and to alter or modify the trust to a greater or less degree by virtue of the Cypre doctrine. So that, in my submission, is a correct statement of the law as set out in the construction industry case and Chinachem. It is that the jurisdiction is limited to the normal trust jurisdiction, the Cypre jurisdiction, and the administrative scheme jurisdiction, and there is no suggestion there of anything more.
Could I just ask you, and I may be asking a completely naive question, but I'm a bit rustier in trust than some people here. In situations where trustees are concerned that behaving in a certain way might place them in breach of the trust, then they apply to the court for directions.
Yes.
In situations where they find themselves unable to perform the trust, they may apply to the court to authorise a scheme, a Cypre scheme.
Yes.
What's meant by surrendering a trustee's discretion?
Well, it's where the trustees don't want to take the decision themselves, and they want the court to take the decision for them, as in this case, where it's a decision that is, well, particularly momentous, is where they don't surrender their own discretion. They tell the court, this is what we've done, can you bless it? If they don't even want to take the decision, but they want the judge to do it, then they surrender their own discretion to the judge. That's what Public Trustee and Cooper says they're entitled to do. But obviously it's only in limited circumstances that first the Charity Commission will be prepared to approve that, and secondly the court will be prepared to do it. The court isn't in every case going to say, we'll do it for you. At the end of the day, that is the trustee's role.
Well, quite.
Yes. That really is the underlying problem. It's part of the principle of non-intervention that the courts apply, that they won't intervene unless either asked to do so or required to do so. My lords, my lady, could I take you secondly to an old version of Tudor on charities? It's the 1906 version, but it contains rather more extensive discussions of the jurisdiction of the court. And there is an informative passage at MS 1679. I'm sorry, we're in tab 50. Sorry, 1680 is the where the passage actually starts.
It's Tudor 1906.
It's Tudor 1906, my lord, yes. Yes. Obviously, given that we're dealing with inherent jurisdiction, one would assume that the principles are likely to be the same. And there's a passage at 1680 headed Jurisdiction of the Court and the Crown. It's been already stated that the Court of Chancery always had the same jurisdiction in respect of charitable trusts as it had in respect of private trusts, namely to enforce the trust and to redress breaches of trust. This jurisdiction was not, however, adequate to meet the requirements of charities, for although it might enable the court to deal with cases where the objects of the trust were defined and capable of taking effect, it would not enable it to carry into effect a general charitable intention or to provide for the CPRE application of a gift, the primary object of which had failed. Accordingly, in the case of charities, the court exercised an extended jurisdiction, probably derived from a supposed delegation to the Chancellor of an authority derived from the prerogative of the Crown as parens patriae, to define and prescribe, so far as necessary, the objects of the trust. This is the jurisdiction usually known as the jurisdiction to establish a charity. And then it goes on to say it depends on the existence, probably depends on the existence of a trust. And if there isn't a trust, then the Crown has to intervene with the sign manual. So again, the jurisdiction is the trust jurisdiction and the scheme jurisdiction, and no suggestion of anything wider. Can I then pick up on the authorities? And I can take these a little more quickly because my learned friend has taken you through a number of the relevant passages. But there is one passage in the Construction Training Board case that I ought to take you to. This is in tab 1. Bundle 1. Tab 12, it starts at MS 707. And my learned friend has taken you to the detailed passages from Lord Justice Buckley. I wasn't proposing to go back over those again. Your Lordships and my Lady have read them. We say that what is clear from that passage, as my Lord Wilson observed, is that there are only the two heads of jurisdiction. It is the trust jurisdiction and the scheme jurisdiction, and nothing more emerges from what Lord Justice Buckley described in construction industry as being the charitable jurisdiction. It is, however, worth going to MS 715, where Lord Justice Russell deals with the same point. He says, I don't find much guidance on the point now in debate that from these references, the court has always had a general jurisdiction in respect of enforcement of trusts, and in relation to trusts of property dedicated to a charitable purpose, a special jurisdiction by way of scheme to amend defects in machinery and further to direct, in proper cases, a CPRE application of assets. So that is, again, entirely orthodox and entirely consistent with what I showed you in Hallsbury's and the old edition of Tudor, and also consistent with what Lord Justice Buckley says at pages 720 to 721. Now, my learned friend read you and places some reliance on what Lord Justice Russell says at page 718, between 718B and C. And there is a comment there that the reference to the control of the court in the exercise of the stated jurisdiction is designed to point to a charitable institution in respect of which the court has power generally to supervise and direct the administration. And my learned friend relies on those words as suggesting there must be some wider jurisdiction. Now, my lords, my lady, we say in light of what the other passage I've read you as to what Lord Justice Russell had just said, it seems what he had in mind there was the administrative scheme jurisdiction. It's difficult to see it as anything else. Certainly there's no authority cited for anything going beyond that. None of the other judges agreed with him that there was any wider jurisdiction, if that's what he was trying to say. And so far as we can tell, no one has ever relied on those words in that judgment to suggest that there is some wider jurisdiction. It doesn't appear to have ever been cited for that purpose afterwards. So in our submission, there is nothing in Construction Training Board that indicates there is any jurisdiction going beyond the trust and the scheme jurisdictions. My Lords, my Lady, the other case on which my learned friend relies orally, he relies in writing, he also relies on the Royal Society case, but I won't go there as my learned friend doesn't, and it doesn't really add a lot. But he relies on the Re-Lang case as saying that shows a jurisdiction simply to do what is expedient. Re-Lang is in bundle 2 at tab 20. Sorry, tab 30, MS 1221. Before I deal with Re-Lang, which is really the only scheme case that my learned friend relies on, it is worth just taking a step back and asking what the purpose of this authority is and what the argument is that my learned friend is pursuing here. In his written case, what appeared to be said was the scheme jurisdiction goes beyond merely making CPRE schemes or administrative schemes in some narrow sense, and it entitles the court to do what is expedient. That is therefore evidence of some wide jurisdiction in relation to charities. That was my learned friend's written case. Orally, he's put it slightly differently, and he says, well, if necessary, he would say that what the Chancellor did in this case was actually order a scheme. And therefore, one needs to ask the question, does the scheme jurisdiction embrace this? As I say, that's not part of his written case. It was what he advanced in the Court of Appeal. I will deal with it because it raises precisely the same points. First of all, how do you get over the threshold into an administrative scheme? What do you have to establish to get jurisdiction for the court? And secondly, having got over the threshold, what does the court then have power to do? Does it have power to direct trustees to take particular decisions? We say the answer is no. If I can invite you to turn to Re-Lang, and the passage on which my learned friend relies starts at MS 1224. And it's the submissions of Mr. McCall for the Attorney General saying that the court has unlimited jurisdiction to regulate the administration of a charity, which jurisdiction depends neither on statute nor on the CPRE rule. Now, there are 2 points to draw out of that, leaving aside the fact it's submissions, but submissions from someone very experienced in charity law. The first point is that what Mr. McCall is talking about there as the jurisdiction is the administrative scheme jurisdiction, and I'll show you that in a moment in his submissions. The second point is that, that's the threshold point. The second point is that when he talks about the unlimited jurisdiction to regulate the administration of a charity, he's not saying the court has unlimited jurisdiction to administer a charity, and there is in our submission a critical difference. And a man as careful and learned as Mr. McCall was no doubt aware of that difference. If I can deal with the first point, which is that what he's inviting the court to do here is an administrative scheme, one sees, first of all, on page 1224, he addresses the question of whether there can be a CPRE scheme under Section 13 of the Charities Act 1960. And he explains at the bottom of that page, and this is important when one looks at the administrative scheme point, by letter H, he says the present size of the fund and the way it has operated means mandatory distribution would involve either turning off a tap or turning it on so hard as to swamp recipients who have come to depend for their work on a steady flow of support. And then over the page at B, he says, if the Attorney General is wrong in his submission that the case involves more than mere machinery, then it follows from his argument that the jurisdiction conferred by Section 13 can and should be exercised. So that's his CPRE argument. Follows from his can and should be exercised, that this case is one in which the jurisdiction to rectify failings in machinery should be exercised. So he's saying if he's wrong about his CPRE argument under Section 13, there has been a failure of machinery, and therefore you're within administrative trust territory. And the reason is over time, the trust has fallen out of, become obsolete, and you either, if you don't get rid of this requirement to distribute all the funds, you're either going to swamp everyone, or you're going to end the fund and no one's going to get any benefit. So this is a straightforward administrative scheme case. One gets through the threshold or the gateway of the administrative scheme because there is a failure of machinery. One doesn't get through it because the court somehow thinks in some vague way that it would be expedient to rewrite the trust. It's acting on perfectly orthodox rules here as to when an administrative scheme applies. And that is what the judge does in the passages to which my learned friend showed you later on. He says it is expedient here to order a scheme, and he orders an administrative scheme. But he does it on perfectly orthodox rules. He gets through the threshold because there is a failure of machinery, as Lord Justice Russell later on says is the requirement, and having got through the gateway into the scheme, he then makes a perfectly orthodox order. He orders a scheme which rewrites the Constitution by removing the requirement for distribution in 10 years. What he doesn't do, or come anywhere close to doing, is ordering anyone to take particular acts as a trustee. It's the difference between administering the trust and regulating the administration. And that's what he's doing, regulating the administration.
Can I just ask, if instead of surrendering their discretion to the court, the trustees, or at least the ones who weren't conflicted, had exercised the discretion themselves and had decided to go ahead with the proposal, and then the member declined to approve that under Section 217, what then?
That would have been the end of it, my lord. Unless my learned friend is right in saying there is a general power to order a member to do what is expedient. There are two possibilities. One is someone could have come to court and said, you, the judge, have power in your charitable jurisdiction to order Dr. Lehtimaki to vote in favour. If my learned friend is right, then that could have happened. The other is that someone could have challenged Dr. Lehtimaki's decision on traditional grounds, said this has been done in, it's not an exercise for a proper purpose, taken account of irrelevant factors or whatever else, but it's obviously a high threshold.
Yes, and he might have been removed under the articles.
Or he could have been removed, that's the other option.
Yeah.
And I'll come back to that when I deal with the trust jurisdiction, that if one was going down a Letterstead and Brewers type argument, that's what you do. You'd remove Dr. Lehtimaki and replace him with someone else. But that's not an application that's been made. No one suggested there are any grounds for doing that. But I was going to come back to that. But if I may say so, my lord, with respect, that is actually a useful way of looking at it.
It makes me wonder what the magic is in the court taking the decision rather than the trustees.
In answer to the point my Lord Briggs was putting to me earlier, one could simply look at it from the point of view of what happens if no one had ever gone to the Chancellor. All that happened is the trustees had said, we're approving this. They hadn't gone to the Charity Commission initially. They just said, we're approving it. Then they'd gone to the Charity Commission to get approval under Section 201, and then Dr. Lehtimaki had taken his decision under Section 217. That, in a sense, does isolate the different stages and shows why what the Chancellor was doing was just that bit, the first bit, and it doesn't impact on the third bit. It may be relevant to Dr. Lehtimaki to think about, to see why the Chancellor thought this was a good idea, but it doesn't bind him. My lords, my lady, we have in our written case, we've dealt in quite some detail with the scheme jurisdiction and the way in which schemes work, both as to how you get through the gateway or the threshold and what you can then do. I'm not going to trouble you with the detail of all the cases I've referred to there, particularly when the learned friend hasn't gone to any of them. But we have done quite a bit of digging into the various Commonwealth jurisdictions, particularly Canada and Australia, to see if there's any helpful guidance. Because it's common ground that one of the difficulties in this area is that a lot of the decisions are taken in chambers and never get reported. And curiously, there is a debate that's gone on over the last 20 years between Nova Scotia and Vancouver as to exactly what the administrative jurisdiction and the CPRE jurisdiction is and quite how far it extends, with the Nova Scotia Chief Justice taking the view that one is entitled to start rewriting the investment provisions of a trust to make it work better in this day and age where they've become obsolete, and those in Vancouver being rather more reticent about whether the court has this power under an administrative jurisdiction. And they're all very informative, but they're all miles away from this sort of case. What they're all about and debating is the question of whether, when the investment provisions have become obsolete, you can then, as a court, walk in and rewrite them. It's quite similar to the Royal Society case, which my learned friend refers to but hasn't taken you to, that you don't have to have you don't have to have a failure of machinery in the sense that the trust is unworkable to get an administrative scheme, but you've got to have something that has changed over time that means that it has become seriously inefficient. And if your lordships are troubled about this point, I would invite you to read the one case I put in, the Sydney and North Saanich case, which discusses, it's the most recent Canadian case, and it discusses the debate that's been going on in Canada, but frankly it is so far from the facts of this case that it doesn't really tell you much more than that the Canadian courts are debating the same boundary that was being debated in the Royal Society case, but no one is considering using a scheme jurisdiction to tell people how to vote. And in our submission, that is the right approach. And this is something that my learned friend, Lord Pannick, and at least to date the Attorney General, have simply not grappled with. What is the threshold for getting into the scheme jurisdiction? And when you're in there, what do you have the power to do? And we say each of those is a fatal problem with the inherent jurisdiction argument that's being put forward. Certainly as far as English law goes, the furthest that any court has ever gone is the Royal Society case, which my learned friend refers to in his written argument. It may just be worth taking you to it, although he hasn't, just to show that this really is the limit of the jurisdiction. It's in Bundle 2, tab 31, MS 1235.
I'm sorry, could you repeat that number?
MS 1235,
Thank
my
you.
lord. And in a sense, this is a more helpful case, actually, to my learned friend than Re Lang, because Re Lang is an out-out administrative scheme case where there is an obvious failure of machinery. Royal Society, the law is pushed a little bit further, in that the problem there was that the Royal Society had two issues. One, that its investment powers had become obsolete, and secondly, that it had lots of different trust funds that were all in different pools, and it wanted to accumulate into one so it could manage them more sensibly. So there was no failure of machinery in the sense that it couldn't work. It was just working very inefficiently and not in a way that one would set it up had one done it in 1955 when the case came to court. And if we pick it up at 1236, MS 1236, right at the bottom of the page, John Brunyate for the Royal Society, he's very doubtful as to whether this is an administrative scheme case. He says, as to the question of jurisdiction, it would appear to be doubtful whether the court has power under its general jurisdiction to sanction these proposals by way of scheme, for a scheme is normally made only where it is impracticable to carry on under the existing trusts or in order to prevent grave loss or injury to the property or objects of the trust. So he is taking effectively failure of machinery to mean it's unworkable, that the trust has stopped working. And then on 1237 we see Mr. Buckley again for the Attorney General, and he says that the court exercises over trust and equitable jurisdiction says charities occupy a special position. This is the passage I read from Leonard Friend's written case earlier. He says, because of the parents patriae jurisdiction, the court has a wider jurisdiction. And Mr. Justice Vasey...
So could you read that?
I'm sorry, yes, I'm very happy to read it. I'm taking this to you, taking your lordship and relating to this, because although this is actually assistance to my learned friend, and this is a passage he relies on, I do want you to be clear where the boundary lies, because even though he says this helps him, it is so far from the current case, and this is the furthest any court has gone. Mr. Buckley for the Attorney General, the court exercises over trusts and equitable jurisdiction. Charities occupy a special position, for the court has a wider jurisdiction in respect of charitable trusts than in the case of private trusts, owing to the Crown's function as acting for parents patriae in matters relating to charity. The function of the Attorney General on behalf of the Crown is to protect charities, and accordingly, in cases where the consent of the Attorney General is obtained, the court has jurisdiction to make orders varying or relaxing the strict rules of equity with regard to charitable trusts. In making such orders, the court is not departing from general rules of equity, for in respect of a private trust, where all the beneficiaries are sui juris and agree to the trustee taking a certain course, the court will sanction the proposal in question if there is nothing which affects the conscience of the trustee. And then the judge asks, what is the precise function of the court in these matters? Who has the last word? And Mr. Buckley says the court. The Attorney General cannot bind his successors, and therefore he requires the protection of the court. Did you want the next bit?
Just over the page.
After the reference to Sherborne and Clephane, he says in Attorney General and Bishop of Worcester, is that it? It was said that it is for the court to satisfy itself that the application made to it, if granted, is in the best interests of the charity. It would therefore appear that there is a general jurisdiction in the court to entertain such an application as the present. So the question here is, does the court have jurisdiction to order a scheme where the charitable trust is working, but working badly? And Mr. Justice Vasey accepts Mr. Buckley's submissions that it does. But it is worth seeing what he says. At 1239, reasons why he does this, he says in the middle of the page, the other proposal, he says the extension of the permissible range of investment is, I think, recognised as a method of correcting the ill effects of monetary inflation, and such extension, if carefully framed and judiciously utilised, possesses advantages which are indeed fairly obvious. I should like to give effect to this second proposal if I can. And then over the page at 1241, he says about 8 lines down, I propose by way of a scheme to make an order in terms which I will presently mention. This is, in my view, an exceptional case. There is evidence the Royal Society takes special care in selecting and varying investments. It by no means follows that the range of investment ought to be widened, as of course whenever a charity finds its available income less than the trustees of it would wish. The existence of a multiplicity of trusts under the administration of one trustee ought not in every case to be regarded as justifying a pooling of investments. The jurisdiction which I hold that I have should, in my judgment, be exercised sparingly and not indiscriminately. So this is a case in our submission, and the reason I show it to you, where one has just about scraped over the threshold into the administrative scheme jurisdiction. But this is right at the limits. This is the furthest one ever finds a reported English case on what is meant by failure of machinery. And it's nowhere, well, there is no failure of machinery in our case, and in terms of the order made, it is nowhere close to what the Chancellor did in this case. So, my lords, my lady, I've tried to meet the substance of my learned friend's case rather than complaining that he's put it in a different way today. But I say it doesn't help him, whether he relies on the scheme jurisdiction as demonstrating some wider jurisdiction, or whether he relies on the scheme jurisdiction directly and says, well, the Chancellor effectively made a scheme. It doesn't matter. There was no jurisdiction for the Chancellor to make a scheme had he been asked to do so. And had he been asked to make a scheme, one of the things he could not have done was used it to direct Dr. Lehtimaki how to vote. But it doesn't arise because he was never asked to do so. This cannot have been what the Chancellor had in mind when he was exercising his discretion, that he was making a scheme. The Charity Commission hadn't authorised any application to him for a scheme, which they ought to have. Can I deal then with the one non-scheme authority on which my learned friend relies, and that is I say one, it's two on the same point, the case of Ashton and Oldham. And these are the cases in which the court has the power to authorise trustees to sell property where it is in the interests of charity. The important point to note about these cases is that in each of them there was a statutory power to approve the sale, and if we can go to Oldham, I'll take you to Oldham first, it's in Bundle 1. Tab 24 starts at MS 987.
987.
987.
Yeah,
Lord.
thank you.
And the relevant passage is at 995, first passage. And at 995C, Lord Justice Dillon says, it's not in doubt as a general proposition that charitable trustees who hold land as part of the permanent endowment of a charity or land which has been occupied for the purposes of the charity have power to sell that land with the consent of the court or of the charity commissioners. That power may be classified as a power conferred by Section 29 of the Charities Act 1960, which replaced certain acts of 1853, that's Samuel Romilly's Act. General power at common law curtailed by Section 29 of the Act, and previously by the Acts of 1853 and 1855, which made the consent of the court or the charity commissioners necessary, or a power conferred by Section 29 of the Settled Land Act. So there is no question here the trustees have the power to make a sale, and it's to be done with the consent of the court by statute. So, in a sense, why one is getting into the question of whether there is an inherent jurisdiction for the court to do anything to authorise the sale is unclear. It seems unnecessary. But to the extent that the court does get into that question, it's in the passage that my learned friend showed you at 999. And it's entirely derived from the six-line judgment of the Master of the Rolls in Re Ashton that my learned friend took you to. There is an assertion of some general inherent jurisdiction to approve sales of property. But it's entirely unclear, both from Oldham and from Ashton, what is the basis for this jurisdiction. And given that it is in any event derived from statute, it's not at all clear why, in either case, the judges thought it necessary to go down this alternative road. But if one is trying to work out what the jurisdiction comes from, it may simply be that this is a precursor to the momentous decision type case, but it is certainly a case where the trustees have come to the court and asked the court to help them. It's not a case of the court reaching out to tell trustees what to do. And in our submission, it doesn't begin to justify some wide charitable jurisdiction said to exist beyond the scheme and the trust jurisdiction. Lords, my lady, that was all I was going to say about the charitable jurisdiction in its narrow confine, and I was then going to turn as briefly as possible to the trust jurisdiction, which I can deal with, I hope, more quickly, because although, as I say, it doesn't seem to be advanced with as much enthusiasm, it is advanced, and my learned friend Mr. Pearce makes some remarks about it, and as he's coming after me, I ought to preempt what I want to say about those comments, but I will deal with this as quickly as I can. Could we start with Lewin on trusts, please, which is in Bundle 3, at tab 46 and MS 1625. This is helpfully headed at 29336, the principle of non-intervention, which I say permeates all the court's approach both to trusts and charities here. And 29336 said where a power is given to trustees to do or not to do a particular thing in their absolute discretion, the court will not restrain or compel the trustees in the exercise of that power, provided that their conduct is informed, bona fide, and uninfluenced by improper motives. And there's then a quote from the Master of the Rolls in Tempest and Camoys. It's settled law that when a testator has given a pure discretion to trustees as to the exercise of a power, the court does not enforce the exercise of the power against the wishes of the trustees, but it does prevent them from exercising it improperly. The principle is both that the court will not interfere before the trustees have acted to compel a particular exercise of the power, and except as stated that after they have acted it will not overturn their exercise of the power. The mere fact that the court would not have acted as the trustees have done is no ground for interference. The set law has chosen to entrust the power to the trustees, not to the court. And it says the cases contain many examples. I won't take you through that. But in passing, it's also worth noting at 29338, the authors say charitable trusts are covered by the same principle. And there's then a reference to the re-beloved Wilkes case about selecting boys for education. So that is the general principle of non-intervention, and it doesn't really seem to be in serious dispute that that is the approach of the courts. I do want to show you very briefly what Lord Walker says in Pitt and Holt, simply to pick up on one of the points that the learned friend makes, but one can find a host of authorities to justify that principle, and Pitt and Holt is probably just the most recent and authoritative. It's in Bundle 1, tab 25, MS 1001. Pitt and Holt, there were two cases being heard together there in which the trustees had taken various steps which they sought then to have declared ineffective on the basis that they had failed to take account of material considerations, the material consideration being the tax consequences of what they'd done. And the key issue there was whether the court could intervene to unwind the transactions if the trustees had merely been mistaken as to the tax consequences, or did they have to have acted in breach of duty? And the only judgment is that of Lord Walker, with whom the other 6 judges agreed. And the first passage to which I wanted to take you is at MS 1032. Paragraph 73 of the speech of Lord Walker. He says, in my judgment, Mr. Justice Lightman was right to hold that for the rule to apply, that's the Hastings-Bass rule that entitled the court to intervene, the inadequate deliberation on the part of the trustees must be sufficiently serious as to amount to a breach of fiduciary duty. Breach of duty is essential in the full sense of that word, because it is only a breach of duty on the part of the trustees that entitles the court to intervene, apart from the special case of powers of maintenance of minor beneficiaries, where the court was in the past more interventionist. It is not enough to show that the trustees' deliberations have fallen short of the highest possible standards, or that the court would, on a surrender of discretion by the trustees, have acted in a different way. Apart from exceptional circumstances, such as an impasse reached by honest and reasonable trustees, only breach of fiduciary duty justifies judicial intervention. And he then refers to the case of Carr and British Leyland, which was a case, I've referred to this in my written case. It's a case where someone was challenging a decision of certain trustees as to whether or not he was entitled to disability benefit. And the judge had said that the trustees had not taken account of the right matters, and the judge had substituted his own view that the applicant was entitled to disability benefit. And at the bottom of the page, the judgment is recorded of Lord Justice Fox, saying, Lord Justice Fox made plain that the Corporate Trustees Board was not at fault. There had been a failure of communication. As to the judge's declaration that Mr. Carr was entitled to a pension, Lord Justice Fox stated, I do not think he was entitled to do that. The decision whether to accept the claim is one for the trustee and not the court. It seems to me that in the present case, the decision of the trustee was simply ineffective, since the board did not carry out their duty to give a properly informed consideration to the claim. That, however, does not entitle the court to substitute its own view of the claim for that of the trustee. I would therefore discharge the order of the judge and substitute an order that the decision of the trustees was of no effect, and the trustee should reconsider the claim. And those two paragraphs in our submission are orthodox and helpful in the sense that they show that the court only intervenes in a normal trust case where there is a breach of trust, and where it does intervene, what it doesn't do is start making the decisions for the trustees. It hands it back to the trustees if it trusts the trustees to make the decision. If it doesn't, as in Lehtimaki and Brewers, it then replaces them with someone else. The final passage I wanted to show you, again because my learned friend relies on part of it, is paragraph 88 at 1036. I'm sorry, put it more correctly, it picks up on a point that my learned friend relies on. 1036, paragraph 88, Lord Walker says, finally, there is the submission that the trustee's duty to take account of relevant considerations is to be interpreted as a duty to act on advice only if it is correct. In effect, a duty to come to the right conclusion in every case. I've left this submission until the end because it is, to my mind, truly a last-ditch argument. It involves taking the principle of strict liability for ultra vires out of context and applying it in a different area so as to require trustees to show infallibility of judgment. Such a requirement is quite unrealistic. It would tip the balance much too far in making beneficiaries a special favoured class at the expense of both legal certainty and fairness. And then the important bit, it's contrary to the well-known saying of Lord Truro in Re-Beloved Wilkes Charity, and he then reproduces the passage which my learned friend read to you from that case, which ends with the reference to except in particular cases. And he says the trustee's duty does not extend to being right, the accuracy of the conclusion arrived at on every occasion. The particular cases which Lord Truro had in mind may have included cases concerned with the maintenance of minor beneficiaries. And your lordships and my lady, you may recall the reference earlier where he said those were peculiar cases where the court acted in a more interventionist way. And then secondly, they may also have included cases such as Carr and British Leyland, in which the trustees have to make a particular factual judgment rather than exercise a wide discretion. The reason I've shown you that is because my learned friend tries to get something out of the words except in particular cases and said, well, Lord Truro must have envisaged some wider jurisdiction. That, as far as we can discern, is the only case in which those words have been considered, obviously considered at a very high authority, and it doesn't appear that the Supreme Court in that case envisaged that there was some wide-ranging jurisdiction meant by the particular case's reference. We say that is right. So the general position in our submission is well established of non-intervention, and the only way around it that my learned friend suggests, and my learned friend Mr. Pearce picks up on it as well, is the possibility of a Lehtimaki and Brewers type intervention. It is worth noting that although Mr. Pearce does deal with this in his written case, he does not invite the court to adopt that argument. He recognises it would be a very substantial inroad or increment in the law. There are 3 points to note about the Lehtimaki and Brewers argument. First of all, both those cases, as I'll show you in a moment, involved serious breaches of trust. Secondly, it's wrong to say that the test is simply what is in the interests of the beneficiaries. That's not the test put forward in either of those cases. It is whether there is some danger to the trust fund or the trust is not properly being executed. One really only has to state the general proposition to see why it's wrong. It cannot be the case that the court has the power to intervene wherever expedient to tell trustees what to do. That would drive a coach and horses through hundreds of years of law, would mean that what I just shown you in Pitt and Holt was wrong. And the third point is that the response in Letterstead was to replace the trustees. As I say, there is no explanation for the jump from that to how one gets to directing trustees how to act. Can I then just make those points in a little more detail by reference to the cases themselves? If we start with Letterstead, which is Bundle 1, tab 19, MS 811, and starting at MS 828. Perhaps we can go back to 823 first, just to give it the context. At 823, right at the bottom of the page, towards the bottom, there's a heading second. And this is what the board was charged with, the board being the executors and trustees, that they had wrongfully and unlawfully charged and appropriated a commission of 10% on transactions, whereas they were only entitled to not more than 5%, and they had improperly charged a very large sum of money, which the board has refunded £21,000, and that was £21,000 overcharged in the 1870s, so probably running to over 1 or 2 million today. It was a very serious overcharge by trustees, and Lord Blackburn picks that up at 828, where he refers to the fact that the compromise he refers to at the top of the page, the terms of the compromise, and then 1, 2, 3, about 8 lines down, just after the various numbers, he says the compromise equally binds the defendants insofar as they admit that a very considerable sum beyond what they were entitled to had been taken by them, and that's the £21,000. So they're admitting they've overcharged a very considerable sum. And then jumping down over the next paragraph, as regards the accounts after 1872, their lordships find it difficult to understand how it was possible for men of business to think themselves entitled to the large sums charged by them in the 11th liquidation account for commission and disallowed under the 2nd and 3rd exceptions. The commission charged on the sum of £4,000 odd and disallowed by the referee is perhaps more extravagant still. Nor can their lordships understand, even with the assistance of counsel, why the sum in question was entered as it stands. It seems not to have been understood by the plaintiff's advisers nor by the referee. At the bottom of the page, again, it is impossible to suppose the executors could really have thought themselves entitled to the sums charged by them but never paid for taxation in the master's office. And then jumping over the next paragraph, but though their lordships acquit the board of concealment in these accounts, the spirit which permeates such charges is naturally offensive to the appellant and unfair towards the trust estate. And then they say in the next paragraph, it's quite true that friction or hostility between trustees and the immediate possessor of the trust estate is not of itself a reason for the removal of the trustees, but where the hostility is grounded on the mode in which the trust has been administered, where it has been caused wholly or partially by substantial overcharges against the trust estate, it is certainly not to be disregarded. And at the bottom of the page, what they do is they say the board should no longer be trustees. So, my lords, my lady, in my submission, a strong case and evidence of the sort of case one requires to invoke the Letterstead and Brewer's jurisdiction. We are nowhere near that in this case, ignoring the fact that the Chancellor wasn't even asked to exercise this jurisdiction, but leaving that aside for the moment. Wrightson and Cook is no better. My learned friend hasn't taken you to it, so perhaps I can just show you the final part of that for completeness, given that my learned friend, the Attorney General, may wish to refer to it. Wrightson and Cook is at Bundle 2, tab 32, MS 1248. This was a case in which the trustees had in fact admitted being in breach of trust. What they had done is that they had invested in breach of trust, but their argument was, well, they'd made good any losses that had been suffered. Mr. Justice Buckley was pretty unimpressed by that, and particularly by the fact that they had sent a report to the beneficiaries of what had happened with various solutions, which he thought was quite improper, and we see that at 1248. 1248, there's a reference in the bottom part of the page to the action coming on before Mr. Justice Buckley. And it said, this case having been opened on behalf of the plaintiffs, there was referred to a document which is before me, which is called Report of the Trustees' Solicitors on the Present Position of the Matter for the Information of the Members of the Family, particularly those who are not represented by legal advisers with ultimate courses of adoption. The passages which were read so startled me that it seemed to me it was impossible for the defendants to defend the course they had taken. I intimated that to Mr. Buckmaster, who appears for the defendants, and he thereupon submitted to pay the costs of the action. The document, so far as I have seen it, seems to me to be a most improper one. So that was what happened when it came before Mr. Justice Buckley Senior, and it then was revived in front of Mr. Justice Warrington with an application that the trustees be removed, and he dealt with that at MS 1258. Right at the bottom of MS 1258, he says, Mr. Cave, as one argument or as one reason for the removal of the trustees, said in effect, we do not like to have these persons who have been charged with a breach of trust and have admitted it, and who've made that statement which is set out in the pleadings in custody of our trust estate. That is not enough, especially when there are other Settee Key Trust entitled. A somewhat similar question arose in the case of Forster and Davis, in which Lord Justice Turner expressed the view which I've just expressed, that disagreement between the Settee Key Trust and the trustees, or the disinclination on the part of the Settee Key Trust to have the trust property remain in the hands of a particular individual, is not a sufficient ground for the removal of the trustees. You must find something that induces the court to think that the trust property will not be safe, or that the trust will not be properly executed in the interests of the beneficiaries. And then he concludes that that is not the case on the facts before him, even though the trustees have admitted a breach of trust. As I say, my lords, my lady, we are miles away from that in this case. There is no suggestion of danger to the trust fund. Indeed, Miss Cooper's complaint is the opposite. She says that she fears Dr. Lehtimaki might exercise his powers to preserve the trust fund by not making the payment of the grant. But in any event, one doesn't come close to this, and the Chancellor wasn't asked to make his order on this basis. There is the further problem that even if one could get into the Letterstead and Brewers type scenario, how does one move from removing trustees, which is what Letterstead and Brewers says can be done, to the court taking over the role of the trustees and telling them what to do? And neither my learned friend Lord Pannick nor my learned friend Mr. Pearce explain how one makes that jump. Anticipating, or trying to anticipate what Mr. Pearce may be saying about this, given that I may not have the opportunity to respond to what he says as he's coming after me, could we pick up what he says in his written case, which is tab L of the core bundle, MS 180, and at paragraph 45, Mr. Pearce states the general proposition that the court's inherent jurisdiction in respect of trusts, both non-charitable and charitable, enables the court, when to do so is expedient in the interests of beneficiaries or objects, to direct the holder of a fiduciary power exercisable in respect to the trust property, how to exercise the power. And as I said earlier, expressed that way, it is frankly a startling proposition, and one that rides through all the previous authorities. In fairness to Mr. Pearce, he does not invite you to adopt it, but for completeness, I need to answer it. What he says in paragraph 46.1 is he refers to the Letterstead and Brewers and Wrightson and Cook cases, which I've addressed. In 46.2, he then refers to Rebeloved Wilkes and Pitt and Holt, talking about the particular circumstances. Again, I've addressed that by reference to what Lord Walker said in in Hit and Holt. And then thirdly, he introduces a new authority, Hampton and Earl of Buckinghamshire, and says this is supported by the reasoning in the Earl of Buckinghamshire case. So I should deal briefly with that, which is at tab 17 of bundle 1. MS 802 and 803 is the passage I wanted to show. It's a dispute between a life tenant and the beneficiaries who come after, and the life tenant wants to mortgage certain properties, the consequence of which will be to disadvantage the beneficiaries who may take afterwards. And the question is whether the court has power to prevent that. And by way of introduction, at 802, at 802, Lord Justice Lindley says in the middle of the page, he says, such being the rights of the parties and the position of affairs, it becomes necessary to consider, 1, whether the tenant for life has any power to make the proposed mortgage, apart from the question of whether to make it will be a breach of trust, and 2, if he has such power, ought this court to restrain him from exercising it upon the ground that its exercise would be a breach of trust. So 2, that's the question the court is asking, is this a breach of trust? And we see that again at 803 in the middle of the page. There is a reference to the Settled Land Act, and then 3 lines below that, Lord Justice Lindley says, apart, therefore, from the question whether to create the mortgage will be to commit a breach of trust, it is, in my opinion, clear that the tenant for life can exercise the power to mortgage. So, subject to the breach of trust point, the tenant for life is okay. Then at the bottom of the page, he says, it remains to consider whether the tenant for life can properly exercise this power, having regard to Section 53 of the Settled Land Act. I felt considerable doubt until evidence as to the value of the estates was furnished to the court, but this evidence satisfies me that the proposed mortgage will be unjust to them, that is the remainder men, and that justice to them requires that no such mortgage shall be made, at least until it has been ascertained that no sale at a proper price can be effected. It was forcibly contended by Sir Horace Davy that it was for the tenant for life and not the court to determine what ought to be done, and that so long as the tenant for life was acting bona fide, the court ought not properly to interfere with him. Speaking generally, I think this is true. And this is the passage for which my learned friend cites it. But assuming a tenant for life to be found acting bona fide and with a view to preserve the estates for those intended by the settlor to enjoy them, still an honest trustee may fail to see that he's acting unjustly towards those whose interests he is bound to consider and to protect. And if he is so acting, and the court can see it, although he cannot, it is in my opinion the duty of the court to interfere. Now, one may take the view that the Court of Appeal has gone too far there, and that it's difficult to reconcile that with normal principles, that if subjectively the trustee is satisfied as to what he's done, that is the end of the matter. But even if one doesn't take that view, what is clear in that case is the Court of Appeal was asking itself, has there been a breach of trust? Has there been a breach of trust because even though acting in good faith, the trustee has not taken account of the right matters or has taken account of the wrong matters? But what it's not saying is that the court can simply intervene where there is no breach of trust. That is clear from 802 and 803. So we submit that, with all respect to Mr. Pearce, this does not demonstrate some wider trust jurisdiction. Lord, perhaps I can just wrap up the trust point then in the
Yes.
two minutes or so I have left. There is one other point I ought to address. It's not mentioned by my learned friend Pearce when he's putting this argument forward, but it is the only instance that we have of the courts actually telling a trustee what to do. And my learned friend summarises these if we go back to the core bundle, tab L, MS 178. My learned friend, Mr. Pearce, has helpfully addressed these here. As I say, it doesn't seem to be part of the argument in paragraph 46, but I'm simply dealing with it for completeness. At paragraph 39.3 of his written case, he refers to cases where the exercise of a power becomes impossible, or if the holder of the power is in breach of his duty to consider exercising it. He says the court may intervene to protect the interests of those for whose benefit the power was created. And he refers to Clugg and Clugg, McPhail Dalton and Metoy pension trustees. And then one sees exactly the same references in the next paragraph, where he's dealing with the question of the next subparagraph, 39.4, where he's dealing with what the court then does if it has a jurisdiction. So he's saying if it's become impossible, or if the trustee is in breach of duty, if the court intervenes to protect the interests of those for whose benefit the power is created, the remedies available to the court include directing a particular mode of exercise of the power. And he refers to McPhail and Dalton, Metoy Pensions Trust and Evans, and Pitt and Holt. So, although my learned friend Lord Panic places no reliance on that, and my learned friend Mr. Pearce doesn't put it forward as part of his argument on Letterstead and Brewers, I simply, for completeness, want to show you what that jurisdiction actually amounts to. And the easiest way of doing it is a final reference to Pitt and Holt. If we could go back to Pitt and Holt in tab 25 of bundle 1. At page 1029, paragraph 63, MS 1029. This is summarising a great deal of previous law that was dealt with in McPhail and Dalton, but the easiest way of looking at it is to see the quote that Lord Walker picks up from Lord Wilberforce in McPhail and Dalton, also known as rebadens with deed trusts. And in paragraph 63, in the quote there between G and H, Lord Walker picks up on the quote from Lord Wilberforce saying, I would venture to amplify this by saying that the court, if called upon to execute the trust power, will do so in the manner best calculated to give effect to the settlor's or testator's intentions. It may do so by appointing new trustees, or by authorising or directing representative persons of the classes of beneficiaries to prepare a scheme of distribution, or even, and these are the important words, should the proper basis of distribution appear, by itself directing the trustees so to distribute. And Lord Walker goes on to say that's a reminder that there are various options available to the court. All I would say, my lord, about that is one only gets into this power, as my learned friend accepts, if there's a breach of duty or impossibility of performance, which doesn't arise here. And if one gets into it, the court will only exercise the power, as Lord Wilberforce makes clear there, where the proper basis appears. So there is only one option for the court to adopt. That is not this case, I say, where the Chancellor expressly recognised that a reasonable fiduciary might disagree with him on the grant. Lords, I'm sorry, I've gone slightly over, but I'm making good progress, and I will deal with section 217 tomorrow and then fiduciary duty.
Very well. The court will adjourn. Sit again 10:30 tomorrow.